these events that you've shared with us are in the record. Is that accurate?
I'm sorry, Your Honor.
All these matters that you have told us about are in the record?
Absolutely.
Did the trial court rely upon this when it made its decision about no visitation and a mother having custody?
Absolutely.
And where in the order or transcript does the trial court do that?
I have, in my brief, cited every specific fact in the record to page number, volume number. And in my brief, it outlines the voluminous record. There are over 50 exhibits I presented to the court verifying the record. And the judge's judgment, she analyzes the history in this case, as well as the comments that the opposing attorney has referenced. The judge did not specifically analyze every factor in 36-6106 by going 1 through 16. She did a general analysis and applied that, as well as the restrictive code where she continued to restrict Mr. Cooper's contact
Did she find
with the
that
children.
applicable?
I'm
I'll
sorry,
ask you the same question I asked opposing counsel. Did the trial court find, what was it, 36? 4106. Yeah. Did the court find that applicable?
Absolutely. It is referenced in her judgment.
I've seen two references to it, but I've not seen where the court said, I find this applicable and because of
Okay,
this.
Your Honor, I'll be glad to point that out to you.
Please.
It is on the court's finding of fact. Page 18, subparagraph 13, second paragraph. In addition to the cases cited, the court is
Okay,
considered.
hold on a second. Page 18.
Oh, I'm sorry. Page 18 of her findings of fact, subparagraph 13, a numbered paragraph 2.
It says, in addition to the cases cited, the court has considered TCA section 366406, restrictions in temporary or permanent parenting plans.
Yes, sir.
Does that mean it applies?
I absolutely considered that it applies.
And she also mentions it on page 258 at the top of the next, or excuse me, page 19 at the top of the next page.
Absolutely. And she refers to various applicable case law as well. The case law specifies that the court doesn't have to have a tally of dad gets X number of the statutory provisions and mom gets this. The case law specifies that one factor can make that difference.
Well, if the court finds 366406 applicable, does it have to do a best interest analysis?
I have mixed emotions about that, Your Honor. I don't know that that matters, but if 366406 is applicable, I don't think that the court necessarily has to go through each of those best interest factors because you've jumped to a restriction of parental rights based on some serious concerns of the court. I believe that the record reflects that those serious concerns are Mr. Cooper's mental health, the criminal charges, the stalking, those things. But if the court finds that 366106 must be analyzed first, I think that's been appropriately done by the court. So I think the trial court has, even though she didn't break down 366106, her judgment properly analyzes all of the facts and applies them.
You have given us a comprehensive list of things that husband did to mother and did some of them in front of the children. Has husband done or said things to the children that are concerning?
There's recordings in the record of his conversations with the children. There was an alleged assault on Miss Cooper before they separated. One of the children was present. When he threatened or commented to her about, look at your mother being a whore. The children were in the car with him. When Miss Cooper's windshield was busted out of her car and Mr. Cooper was videoed, he had the children in his care.
Yeah. Those comments are sort of about the mother again. Has he said anything to the children about them?
About the children
About
directly?
the children themselves?
His repeated comments to the children were along the lines that God doesn't approve of divorce, negative things about their mother. I don't remember exactly what the recordings were in the file with the children, but they were religious-based, not positively, negatively. Part of the record is that the children no longer wanted to be with their father or see him. They were expressed concerns regarding his mental health. There was an incident at Barton Field, which is the football field for middle school children. The son, Kyle, was with his mother. The father had been restrained from coming into Henry County for various things. He was at that game. He blows down his window and yells with Kyle in the mother's presence, "You're a piece of shit."
He yelled that at his son?
At Miss Cooper,
At Miss
while the
Cooper,
child
okay.
was next to him.
Thank you.
So, in response to your question, Judge, is most of these events are directed at Jamie Cooper, and our children are exposed and present. Mr. Cooper's behavior directly to the children are behaving in the presence of them. Your mom's a whore. Wherever they might have been when he burst out her car windows. Putting the tracker on her car when the children are present with her. Obviously, he's doing that when nobody's around except witnesses who,
I think you've answered the court's question. And
So-
you used your time.
Okay, thank you so much,
Thank you.
Judge.
Yes, ma'am. Counsel, I believe you got 5 minutes in rebuttal.
I didn't see any evidence of any abuse of the children at all or any harm to the children at all, except for there was one occasion which I admitted and referenced in my brief where the two parents apparently got into a scuffle where Mr. Cooper was trying to take Ms. Cooper's phone, and then Ms. Cooper said that somehow one of the children got her nose hit and it was bloody. But frankly, there wasn't any clear testimony about how that happened or even that Mr. Cooper did it. There certainly wasn't any testimony that either party did it on purpose. And so I wouldn't call that abuse. I wouldn't really say that either party's abusing the children. Clearly, Mr. Cooper has done some bad things, and as I alluded to in my brief, I don't make as big of a deal of it, but I mean, I'd say the wife has done some bad things too. But, and clearly Mr. Cooper has committed contempt of court, and we didn't even appeal that finding. But I submit that basically what happened here was the judge got angry at Mr. Cooper for not only committing contempt of court and maybe just being sort of what she viewed as a bad person in general, in addition to her being upset at his religious views and her being upset at him making comments about her in private and, making the vaguely threatening comment about opposing counsel. And she therefore, in her being upset at those, took it out on Mr. Cooper in child custody, and that was improper.
Are you saying the trial court found the facts inappropriately or incorrectly?
I don't think that on my appeal I'm really taking issue with any factual disputes at all. I mean, the only factual disputes that there even were would be, I think Mr. Cooper said that they were trying to reconcile at one point in about September or October of 2022, whereas I think the wife said, well, she wasn't that interested in reconciling because she already had a new boyfriend. So generally speaking, I'm not really attacking the facts in this appeal. I'm saying that the trial court applied the wrong factors and thereby abused its discretion. And on this TCA 366406, the court is supposed to do an interest balancing analysis because the statute specifically says that the parenting plan shall be limited if the limitation is found to be in the best interest of the child and if one or more of the following things is found. And here the court didn't find anything about the best interest of the child, and it didn't expressly find that he had done any of the things that are listed therein. It didn't say he had sexually abused anyone, didn't say he had physically abused anyone. If you want to say that, him calling his...
Well, what about physical or sexual abuse or a pattern of emotional abuse of the parent, child, or another person living with the child as defined in 363601?
I was about to say, if you wanted to say that his, shouting out insults at his wife and vandalizing her or whatever, if you want to call that emotional abuse, I guess you maybe could.
The court had made all these findings about your client's activities.
What I'm saying is that my client's activities are not physical abuse, sexual abuse, and I don't really think they would even qualify as a pattern of emotional abuse. They're just wrongful acts.
Are you saying the court couldn't construe what we've heard your client, as much as I can understand, admittedly did, could not be considered physical abuse or a pattern of emotional abuse of the parent?
I would say it definitely could not be construed as a physical abuse. Depending on how we want to define emotional abuse, that's what I'm saying. Maybe you could construe it that way. But when I think of emotional abuse, I'm thinking more in terms of we live together and I'm just repeatedly hurting you emotionally. I don't think the fact that he's following her around during their divorce and committing vandalism every now and then and, shouting insults every now and then, that to me doesn't really seem like what I would normally think of as a pattern of emotional abuse. But as I said, that's kind of a wishy-washy term, so maybe it could be construed that way.
I don't
Either
think
way,
it's very wishy-washy.
well,
Emotional abuse is one of those things, I almost want to say you know it when you see it, but it seems to me that the things you outlined there, do indeed constitute emotional abuse, and I don't know how you can stand there and say it isn't.
well, in my world, that term is vague, but regardless, maybe
world do you
that
live in?
could be emotional abuse. But either way, the court did not find that it was in the best interest of the child to limit parenting based on that. And so I do submit that it was an abuse of discretion. If there are any more questions, I can answer them. But otherwise, I would ask that the court reverse the child custody determination and set the custody at 50-50.
Thank you, counsel. Thank both of you for your briefs and your oral argument. We will take this matter under advisement and we'll attempt to render an opinion at the earliest possible time. You may be excused. Thank you.